Okay, perfect. Okay, so Prajit, you go ahead and let's go live. Let's broadcast it. And let us know once you do that in the comments,
Yes,
please.
I will do that.
Okay.
We are live, ma'am. Please go ahead.
Great. So welcome everyone to today's event with JG Human Rights Society guest lecture, Sheikh Jarah, Ethnic Cleansing and Annexation. Allow me first to introduce our honorable speakers for today. Dean and Professor Mohsen Attar. Dr. Attar has had numerous academic positions at a range of law schools, including Warwick, McGill, Queen's, Auckland, and the University of West Indies. Dr. Attar is best known for his writing on third world approaches to the international law, a theory that guides his investigation into global political economy. He researches the role of law in both readdressing and exacerbating economic divisions between different regions of the world. In his forthcoming book with OUP, A Guerrilla at The Hague, he argues that many of the principles of the international economic law preserves a Eurocentric epistemology that favors a parochial view of both human development and human flourishing. You can find Professor Attar's work on his personal website, mohsenattar.org, the International Law blog, Opinion Juries, and SSRN. Professor Attar's latest book on public speaking, Speech Simplified, is available on Amazon. Welcome, Professor Mohsen Attar, with us. We are more than delighted to host you with us today. Professor Samia Uma. Professor Samia is a professor at Jindal Global Law School in India. She has over 27 years combined work experience as an academic, researcher, legal practitioner at the intersections of gender, law, and human rights. She has served as a research consultant on human rights with international agencies such as the United Nations Development Fund, United Nations Office of the High Commissioner on Human Rights, and the International Commission of Jurists. Additionally, she worked as the national coordinator of ICC India, the Indian campaign on International Criminal Court. Professor Uma has taught at top-ranking law school in India, such as National Law School of India, Bengaluru, Maharashtra National Law University in Mumbai, and Emancipate University in Delhi. Her teaching and research address various aspects of human rights, including gender-based violence and reparative justice, feminist jurisprudence, international criminal justice, human rights law, and social justice lawyering. She has researched and authored 11 books, edited and co-edited books by reputed publishers such as the Oxford University Press, and has written and published over 50 articles in journals, newspapers, and popular online media platforms. She has been on the executive board of organizations and networks pertaining to human rights. She is a life member of Indian Association of Women's Studies and member of European Association for South Asian Studies. Welcome, Professor Samia Uma, with us today. We are delighted to have you with us. And last but not least, Professor Brendan Brown. Dr. Brendan Brown is an assistant professor of conflict resolution at Trinity College Dublin. He is also a member of the Trinity Centre for Resistance Studies. He holds an LLB and LLM in law and human rights and a PhD in sociology, all from Queen's University Belfast. He previously taught at Queen's University Belfast and Al-Quds University Bard College in Palestine, where he taught transitional justice and the laws of armed conflict. His research interests are situated around conflict, transitional injustice, violent displacement in conflict and colonialism. He has received research funding for his work from numerous sources, including the Independent Social Research Foundation and the Wellcome Trust. And most recently, he was rewarded a research development grant from the Arts Humanities Research Project, DFID, a project entitled Palestinian Bedouin at Risk of Forced Displacement, IHL Vulnerabilities and ICC Possibilities. Welcome, Professor Brendan Brown, with us. My name is Noel Hind. I am a lecturer at Jindal Global University, and I will be the host and moderator of the event today. So, I'm going to go ahead and start with introducing the conflict for today. In today's conference, we're going to discuss a persisting conflict and issue that has arisen to the international sphere as a whole, the ongoing ethnic cleansing and annexation of Palestinians, specifically in Sheikh Jarah, Silwan, and Lifta. A systematic, forceful expulsion of Palestinians from Eastern Jerusalem has viciously started during and post-1967 war by Israeli military and settlers' forces. Thus, de facto and on-ground procedures of forceful expulsion of Palestinian Jerusalemites and displacement by Israeli settlers were further reinforced through an issuance of several colonial property legislations. As an effort of institutioning land grabbing and Palestinian properties confiscation. From the Absentee Law 1953, the Land Acquisition Law 1950, where the main purpose of it were to confiscate Palestinian lands and properties within a legal framework, while on a parallel stance, Israeli settlers are being granted the right to settle in any Palestinian property per the Return Law 1950, where it's granted any Jewish individual whom are settling in the Palestinian lands the right to take over and own properties in the occupied lands of Palestine. And lastly, and most importantly, for the purpose of our event, the Legal and Administrative Matters Law 1970, where it was tailored specifically for the purpose of confiscating Palestinian properties within the jurisdiction of Eastern Jerusalem. Regardless of the fact that at the time, Eastern Jerusalem was under the international auspices of Jordan. However, for the legal and administrative law and all of the pre-mentioned property legislations, Jewish settlers were successful in land grabbing more than a third of Palestinian lands in Jerusalem only, approximately 24,500 dunams, most of it privately owned by Palestinian, where it built 11 neighborhoods on them for Jewish inhabitants only. Those mass confiscation cause a human crisis, from loss of housing or settler rights to loss of private properties and businesses to forceful evictions and migrations, mass genocides, and lastly, the loss of the Palestinian identity whom were successful to stay in Jerusalem. So those Palestinians who were successful to stay in their lands, which is what we're going to talk about, the individuals in Sheikh Jarah, Beta, and Silwan, they were prohibited from obtaining or their Palestinian ID, and then they were granted with an Israeli residence and not a nationality, thus treating them as immigrants within their own lands and territories. In addition to issuing municipal regulations prohibiting them from urban expansion within their own properties or even owning any new properties in Jerusalem after 1967. The confiscation of Sheikh Jarah neighborhood and village of Silwan and Beta has been an ongoing colonial effort since 1967, as we have just said. The latest Israeli Supreme Court verdict issued against the Palestinian residents of Sheikh Jarah, Silwan, and Beta was in 2009, where it has ordered 5 Palestinian families, amounting to 650 individuals, to evacuate their properties as well. Israeli settlers already have taken over several houses in Sheikh Jarrah during this year and prior to the issuance of the last binding decision from the appellate court. Additionally, the Israeli military and police forces have already cemented and built checkpoints all around Sheikh Jarrah and Silwan, where only Jewish Israelis are allowed to enter, while Palestinians from Jerusalem are prohibited to. In the light of the latest events, we are holding this conference to discuss the latest committed actions by the Israeli government and settlers of annexation and ethnic cleansing of Sheikh Jarrah, Silwan, and Beta within the framework of public international law, the de facto circumstances in those areas through a colonial studies lens, and lastly, the status of victims of such atrocities, especially Palestinian women and children, through a human rights and feminist theories. So, without any further ado, I am going to start with directing questions to our guest, then moving lastly to our audience questions and commentaries, which, by the way, everyone is allowed to go ahead and submit their questions as the speakers are talking. So let's start with situating and framing this conflict or this topic that we're addressing today within the public international law framework. Professor Attar, can you situate the current conflict of Sheikh Jarrah and Silwan and Beta within the framework of laws of occupation or public international law?
Excellent. So thank you for the introduction. It was actually quite elucidative, even for me, just listening to you describe a little bit of the history. Obviously, your knowledge of what is taking place in Palestine greatly outweighs my own. And as I was taking notes, it was making me think about a couple of things. So the first thing that it made me think of is that Palestine is somewhat difficult to talk about. It's difficult to talk about in large part because it elicits then so many different emotions then. That would be one way of putting at it. There's another element though to it as well, which is it's difficult to talk about because of what I would say is the dishonesty that often surrounds the debate. And this I find is one of the greatest challenges, and I'll lead into international law from there. When I say it's the dishonesty surrounding the debate, I think it's important to put in perspective then the nature of Israel as a type of colonial power. And as we know throughout history that colonial powers lie. This is evident. And to suggest otherwise is both ahistorical, unconvincing, and really ultimately silly in the end. But lies can be effective, especially then when people are willing to be deceived. And because of a certain symbolic space that Israel has captured, as a result, we come to embrace many of these lies surrounding then both Palestine and Israel and the conflagration between them. Now, this is what leads me then into international law. And you asked a question then about the law of occupation. Now, occupation is regulated by international law. We see this in the Hague regulations. We see this in the Fourth Geneva Conventions, and there are a number of other treaties then that touch upon it as well. Now, what do these treaties do? They set out the rights and obligations, the protections, the duties to both the occupying power and to the occupied population. Really interesting to think about it there, that those who are occupied also have some duties as well. Now, something to bear in mind then in relation to both the Hague regulations and the Fourth Geneva Convention is that the type of occupation that was envisioned within these treaties were type that were short in duration. Now, of course, short is necessarily subjective, but the idea was that an occupying power is exerting temporary control. It's temporary control over what is effectively then the lands and lives of others. Now, international law permits occupation in instances where the occupying power is seeking to, on one hand, preserve sovereign entitlement, so their sovereignty is somehow at risk, and that is one way. The occupation is one strategy then for repelling this risk. And the second one then is to promote certain humanitarian interests, whatever those happen to be. A lot of the language is quite abstract surrounding it. So an easy example would be then the case of Iraq. So think of Iraq back in 1991. Iraq invades Kuwait, breaching then the sovereignty of Kuwait. To preserve this sovereignty, we have an intervention then by a number of other member states, and also to protect the humanitarian interests of the Iraqi people. They enter, they repel, they temporarily control the region, and then afterwards they exit, temporary control. So the law of occupation could apply in those circumstances. Now, this temporary control, again, we have to situate historically, and we say that it was presumed in the modern era that this notion of sovereignty had won out. The international community would not tolerate any type of invasions and prolonged military occupation. But that is what we're dealing with when looking at the case of Palestine and Israel. We're dealing with a prolonged military occupation, and one that is ill-fitted in terms of the treaties, or better yet to say, the treaties are ill-fitted, ill-suited to dealing with what is in essence then a type of colonial settler then scenario. Now, why is the law ill-suited to deal with it? Well, because acquisition then of territory by force is prohibited in international law. Annexation of occupied lands is prohibited by international law. So what we have then is a disconnect, a disjuncture, a cleavage. We have a law then of occupation, or an international law, an international form of management of occupation that deals with occupation that takes place on a temporary basis for two normative purposes: to preserve sovereign entitlement or to protect humanitarian interests. And then on the other hand, we have this modern form of occupation that Israel is pursuing, a prolonged occupation, a never-ending occupation, and one that contains within it many of the trappings then of settler colonialism that we've seen throughout history. So the challenge then for international law is a renewal of the laws pertaining then to occupation, specifically to account for this prolonged period. And then, as anyone knows, or anyone who follows international law would know, this is an impossibility. So what we are dealing with ultimately is an occupation of exceptional duration, one that makes it very difficult then for international law as it exists within the current framework to mediate.
I see. Thank you so much, Professor Mohsen Attar. I think your answer is very important, and that to say is, especially when you compared or underline the point of the occupation within public international law of occupation was meant to be or drafted to be as a short term or temporary, and that is, as we all know, the argument that Israel keeps rebutting in its international affairs. So thank you for underlining that point for us all. Now, what do you think, Professor Attar, what is the relationship between occupation and public international law? In other words, or let's say, what is the legal characterization of occupation under public international law? And I think you kind of answered that somehow in your previous answer.
So let me start then with a phrase that I often use with first-year law students. And I say the law is really about one thing: who owes what and to whom. That is it. It can be synthesized into that. That is the question that we're always asking: who owes what and to whom? What is this signposting then? That the law is built around legal responsibilities. There are duties, there are obligations, and there are also entitlements and rights. Now, if we look then to occupation under international law, then we see those elements. The occupier has a number of rights and responsibilities in the same way then that the occupied have a number of rights and responsibilities. But again, understand that these rights and responsibilities were conceptualized then within a frame of temporary occupation, and temporary occupation that is motivated then by sovereignty on one hand or humanitarianism on the other. Now, the challenge with the law then, because it was conceived with this temporary frame or within this temporary frame, the emphasis within the law or within the treaties is on management of those rights and responsibilities, and not so much on termination or the steps that are necessary to end the occupation. So this is how effectively Israel has managed to maintain its position. The law itself does not prescribe the mechanism via which we achieve the end of the occupation. All we have is its management. So Israel is managing the occupation in a way that satisfies its needs. Now, of course, we can quibble, we can argue over the needs of the Palestinians and whether or not Israel is in violation of the Geneva Conventions and so on and so forth. But that to me is largely besides the point. It is besides the point because it is evident from everything that has taken place over, and we could argue whether or not we would say over the past 50 years or go even beyond that. we would say then that it is evident that Israel has no intention of ending the occupation. And because it has no intention of ending the occupation, effectively, Israel is leveraging the Geneva Conventions so as to create a permanent state of management. And so this is why we see a variety of mechanisms, whether it happens to be then what you describe as ethnic cleansing, then in relation to Sheikh Jarah, whether we see that, whether we see this attempt to entrench effectively permanent control over what would be then deemed Palestinian lands. So I even find the term prolonged, or the qualifier prolonged occupation, somewhat inaccurate. And I think others have noticed the inaccuracy then of this term prolonged occupation, or even the term occupation altogether. And I'm really very interested to hearing what Dr. Brown is going to say about this, because the Irish have lobbed effectively then what is a grenade into the debate. And they lobbed this grenade just a very short while ago. I think we're talking 1 or 2 weeks now, not much more than that. And what is the grenade that they lobbed? They shifted, or trying to shift the debate away from occupation and toward de facto annexation. Now that is very interesting. And so some of you will have remembered then when Trump was president of the United States, he declared that to the Americans, or at least to his government, then the annexation of Jerusalem was acceptable. Now the response then from the international community, however you want to term it, was that no, it is not. If there is anything then that is a no-go territory for sovereign states, it's the idea that other sovereign states can annex the lands of others. So what we're dealing with then is a situation where Israel is committed to maintaining occupation, not for purposes of control over the Palestinian population, but for purposes of control over the lands. So since it has no intention of ever then ending the occupation, is it really appropriate for us to make use of the laws, the treaties that pertain to occupation, or as the Irish suggested just a short while ago, should we now begin to speak in the language of annexation and to point then to the illegalities of what is in fact taking place?
Thank you so much, Professor Mohsen. I think, before going to another question that I have for you, you've pointed something very important here, which is that, can we really, or at least this is what you were intending to, can we really apply, public international law with its current terminology, or to be more specific, the law of occupation with its current terminology, to Palestine, to the Palestinian case, and be successful in terms of saying, okay, if we do that, if we push the pedestal legally, then maybe, perhaps, we might terminate the Israel occupation. You have pointed something very important. You said that the terminology itself within the law of occupation doesn't provide an environment, let's say, or like a framework, let's say, to the termination of occupation. All what we find when we read really the Hague Conventions or the Genevas, right? When we read the laws of occupation, we only find, as you say, just some articles, some grounds of how to manage the day-by-day life of an occupation. And that, as you said, and you said it very clearly, that is why Israel until now maintained its status, or at least one of the reasons, right? So the question here is, what can we do here? Do we call for, now we see in theory and academia, let's decolonize public international law, right? But how do you think we can go around that? Not just theoretically, but at least, on de facto, to affect the going actions of Israel on ground. How do you think we can do that? How can we go around that? And is it perhaps time to also change the conversation right? Unless, instead of saying, let's frame occupation and what is going on under public international law, maybe let's change the question here, right? Maybe then we've been asking the wrong question all that time, right? So what's your comment on that?
So 2 points come to mind then. The first one is about framing, and I think you're right. I think how you frame a problem then will obviously determine which outcomes then are available to you. And by framing it as a form of occupation, it triggers Geneva Conventions, the Fourth Geneva Convention, it triggers the Hague Regulations, it triggers then a number of, as we said, rights and responsibilities. And so long as Israel continues to operate within that frame, so long as we continue to frame the problem in that manner, then in effect we're circumscribed in terms of what it is that we can do. So I think you're right in terms of the first one. How do you frame it? What is the alternative then? Well, I've already pointed to one of the alternatives, and one of the alternatives is now to recognize that what is taking place is not an occupation, but is a form of annexation. And once you do that, well, then you shift the debate, because now we're dealing with an ongoing case of settler colonialism. Now, the challenge for that, and this is probably the only point that I'll make here then, the challenge for that is that international law itself was designed by imperial colonial powers to legitimize both imperialism and colonialism. That is the nature of it. And so one can go back to, and I've written about this, and many other scholars were known then as Twale scholars, third world approaches to international law scholars have written considerably about this. Go back to the days of Vittoria and then follow through with Grotius and Vattel and Westlake and come right into the modern era. And what we see is international law effectively used then as an instrument to legitimize conquest. And so Canada, for example, is a settler colonial state. The United States is a settler colonial state. Australia, New Zealand, so on. Much of the Commonwealth are settler colonial states. The whole of the Caribbean is a series of settler colonial states. So in those circumstances, settler colonialism is in fact the etiology of international law. It's embedded within the regime. And so to ask or to expect international law to all of a sudden become anti-colonial is, to me, fantastical. It's fantastical because it was never intended to be anti-colonial, quite the opposite. The only reason that we have these protections, the Geneva Convention that you're referring to, is largely because of former colonies challenging then imperial colonial powers within these centers of power, whether it happened to be then in Geneva or at The Hague or wherever else, challenging them and making demands in terms of what they were willing to put up with. And so it was resistance that produced these type of curbs on Eurocentric international law or European international law. So when you say to me, hey, can we use international law to liberate, to emancipate the Palestinians? Well, I'm not an international criminal lawyer, and so I can't really say anything about what's going on at the ICC. But at least what I can say is in terms of humanitarian law, international humanitarian law, it is designed, as I said, through a management lens. And through a management lens, we are already seeing violations of the rights that Palestinians are owed. But to say that Israel is not terminating, not ending the occupation, that in itself is kind of neither here nor there, because the Geneva Convention was not designed with a process via which that termination ends. And since international law is a permissive system, meaning everything is permitted unless it is prohibited, it's a hard place to find then a treaty that specifically prohibits settler colonialism. Instead, what we have are treaties that promote self-determination. But that's a positive right rather than a prohibition on someone to curb their ability to self-determine. So it creates a bit of a conundrum then for legal scholars, and it creates this mess that we find ourselves in today.
true. I absolutely agree with you, Attar. Since we're talking today about the annexation of Sheikh Jarah, Silwan, and Beta as, a case study of the annexation that all of the Palestinian lands have been going through, what is the status of land, and occupation under international law, right? So, this is, maybe a little bit of an abstract question, but that will also help us further develop our argument today in our lecture as we go forward.
I kind of feel that I'm monopolizing the floor here, so I will be very brief in terms of answering this question. So what is evident then in terms of land, if we look then to the Geneva Conventions, is that the occupying power has no rights to the land then of the occupied. What is taking place then there in terms of settlements, and this is why everyone recognizes, well, everyone. This is why the international legal community, for whatever it is that we describe it, acknowledges that the settlements then that Israel has established, whether it's in the West Bank or Gaza, are illegal under international law. There's no possibility of settling. This is something that is explicitly prohibited then. So I said before that international law is a permissive system. Anything is permitted unless prohibited. Settlements are prohibited. That's it. It's very simple, very easy, very straightforward. So the settlements are illegal. We know that. Annexation is illegal. We know this as well. So when you say what is the status of land then, occupied land under international law, well, it still remains then the land of the occupied. So the occupier has no rights to that land then. So again, because we're imagining a situation of temporary control where you're either A, trying to protect your sovereignty, or B, trying to deal with a humanitarian kerfuffle. So that being the case, once then your sovereignty is protected, once the humanitarian then situation is resolved, well, effectively you withdraw and the land goes back then to the natives. But again, I go back to what I said earlier. It is evident that Israel has no intention then of withdrawing, and this is largely a colonial project. So the challenge then for international law is dealing with a situation that is framed as an occupation, as you said earlier, but isn't in fact then the colonization. What we are seeing then is real time, the colonization of Palestine by Israel. And so how do international legal scholars deal with that? Well, for this, we have to then turn to self-determination. We have to then turn to sovereignty doctrine, and you have to turn then to creating what is a pretty robust argument about the rights of Palestinians then to self-determination, to their sovereignty. But again, this is something that has been opposed by other settler colonial states, which is why we've seen then the Americans veto any push then for statehood by the Palestinians, or at least when they can, in the context of the Security Council and such.
Absolutely. And that you've just given us is, kind of regulates settler colonialism itself, not just manage it, it regulates it somehow. An occupier has the right to own and confiscate some land. And then, there's, it depends if it's private, if it's public, if it's being used for military purposes. And, we've seen that, application of those articles 1970s during the first Intifada settlements within the West Bank, where at the beginning it says that they said to the international sphere that, or alleged that those confiscated lands per the land acquisition law that I've just mentioned is for military purposes, for example, and then later on it has been transferred to civil usages. So that's just a simple comment, I think, just to also underline what is really the status of land with occupation under public international law. It is definitely, a tricky question to ask when we're talking about a prolonged occupation or an occupation that has no intention to terminate. What does that mean when we talk about land of natives? Okay, thank you so much, Professor Mohsen Attar. I think by now we kind of have, given our audience, I hope a very, maybe broad and simple and direct framework of our conflict today under public international law. We talk about what is the status of occupation, right? And we talked about what is the status of land under the laws of occupations. Now let's go into the de facto circumstances of our topic today, which is specifically the annexation of Sheikh Jarah, Beta, and Silwan of Jerusalem. With that, so Professor Brendan Brown, what is the current de facto and legal status of Sheikh Jarah and Silwan and Beta, our audience, what is really going on ground at the moment?
Well, firstly, let me start by thanking you, Noel, for the opportunity to join you guys and the Jindal Global University and the Human Rights Society to discuss what I think is a really pressing and an important topic for not just legal scholars. I think what I'm particularly happy about is the interdisciplinarity of our discussion here, because it's really crucial that we move this not just through the lens of law, but through other different frameworks as well, which I think Professor Attar has done beautifully at the start. And also it is a great privilege and a pleasure of mine to share this platform with him and also Professor Uma. So thank you very much for that. And I think I'd like to stress really from the get-go here that last night, the residents of Sheikh Jarah were yet again attacked in their homes with tear gas and crowd dispersal techniques, not only by the Israeli occupation forces, but also by settlers who are enabled by the Israeli occupation forces to engage in this level of terrorism. I think what I want to do when I'm speaking here as well is to be very clear about the language that we use. I absolutely would avoid using the language of conflict. This is absolutely not conflict. This is ongoing ethnic cleansing and a settler colonial reality engaged by a rogue state that has been completely inoculated by the international community. And I think increasingly it's time for us to really be careful with our language and our discourse on that. And this is the intense media scrutiny around Palestine may have died down ever so slightly at the moment because of the genocidal attack on Gaza has perhaps calmed down for the meantime. But what happens is when the media isn't there, all this on the ground settler colonial violence takes place anyway. So the media moves, and it's up to everybody on the ground to really keep the energy going. And you know, when Professor Mohsen said about this being an emotional topic, it absolutely couldn't be more emotional from a personal point of view. I lived in Sheikh Jarah for nearly 2 years. I had the very great pleasure of the hospitality of many friends and comrades whose houses are now subject to eviction notices. And in 2009, I met with the Al-Hanoun family who had been evicted from their homes and moved all their worldly possessions under an olive tree in Sheikh Jarah. And nothing had more of a profound impact on me on a personal level. I think also we need to look at where Sheikh Jarah is physically. Sheikh Jarah is located in the east of the city, right at the edge of what is known as the Green Line in occupied East Jerusalem. The Damascus Gate, Baba al-Mud, which has this real heartbeat about occupied East Jerusalem, connects Sheikh Jarah to the old city via two main thoroughfares, Salahuddin Street and Nablus Road. And within Sheikh Jarah, you have really important familial connections, but also heritage spaces, political spaces, businesses, infrastructures. And alongside that, you have a really strange mix of international development organizations that have engaged in that space, making that neighborhood the place where they want to set up shop to help resolve the conflict, when in fact what their presence does is create an economy that kicks out Palestinians from their homes because they can't afford to live there. Maybe that's a point we'll pick up on later on. And the local mosque has become somewhat of a sanctuary with a number of families who were actually forcibly displaced from their homes in 48 and 67 and ever since, using the sanctuary of the local mosque to live together. And in many ways, this came about as an issue of land ownership, which you've picked up on already. It is also home to the Office of the Quartet, the group of 4 countries led by ex-Prime Minister Tony Blair, whose stated aim is to assist the implementation of the peace process, which is based in Sheikh Jarah, which has been notably silent on this entire conversation. And it is also home to the American Colony Hotel. So, I mean, it is just a whole mishmash of contradictions in many ways. But according to the NGO Law for Palestine, the current, and again, using the word advisably, dispute and subsequent escalation of tension in Sheikh Jarrah is due to the demands of Israeli settlers and the organizations that represent them, which for the most part are based in the United States. And they want to forcibly evict Palestinian families who live in the neighborhood, many of whom are, as I stated already, refugees from '67. And many civilians have subsequently been arrested and injured, protecting their family homes, and as tensions have boiled over. And over several years, a number of Palestinians have been, as I say, evicted, with more than 27 Palestinian families and approximately 500 persons remaining under threat to this day, at the risk of forcible transfer. And what is apparent to many seasoned observers, and perhaps less so, is that this is an ongoing attempt at Israeli settler colonial erasure of historic Palestine by making sure that the demographic reality on the ground is such that any conception or notion of 2 states for 2 peoples is completely pie in the sky and gone. And that is enforced through the colonial court structure and enforced through discriminatory laws and policies. And the aim of the occupation is to transfer ownership of these homes from the original owners to Israeli settlers. And again, based on the work of Law of Palestine and their legal analysis of other rules of international law, Jordanian law, Ottoman legal documents, Israeli documents, what occurring is attempted forceful land theft aided by discriminatory policies. As Professor Mohsen has already emphasized, these are lands that are located in occupied territories. The aforementioned rules deem the legal characterization of the Israeli authorities as an occupying power. But if I could just end this point on by saying, beyond the legal context here, right? We need to situate this conversation within a much wider conversation of colonialism in action. This is part of a greater Jerusalem plan. The idea is to ensure, as I said, that the demography of Jerusalem remains skewed towards the Israeli population. And this is not just happening through forcible transfer, but also erasure of Palestinian presence, the heritage, culture, identity, naming, all these different insidious ways that you erase the context of a people on the ground. And the settlement activity that takes place in this space is creating fragmentation between Palestinian areas in the east of the city. So Silwan gets fragmented from Sheikh Jarah, gets fragmented from Attar. It is a tool of the colonizer to fragment and divide. If you can make the resistance seem weak, then it's an easier way to conflict manage and control. And this is just very similar to other colonial and post-colonial contexts as well. If you look at the Bantustans in South Africa, it was something quite similar in that regard as well.
I couldn't agree more. Thank you, Professor Brendan. And I think I would like, to comment on what you just, last said about the fragmentation of the, geography of the Palestinian lands and areas, and how it is really the root of colonialism, really, and to weaken the resistance, as you have just said. That, thing can go back not just to 1948, but let's talk about, more legally documents, the Oslo Treaty, where, we can see when we read about the categorizations of lands A and B and C. I'm not going to go in deep in that. I'm just going to say that you are right, because this has been already drafted, where it says that all Palestinian lands, B and C specifically, there should not be any two Palestinian points, whether villages or streets, whatever, that is connected. There should be an Israeli checkpoint, an Israeli settlement, to kind of just divide. And that goes into more micro level, into cities and villages itself. I mean, Professor Brendan, I think you can tell how that looks. Maybe that looks a little bit weird when we tell to people who have not been to Palestine that, oh, you know what, there's not any two Palestinian villages or cities are connected. And they'd be like, how? I think because you've lived there. But I think it also is inside, as you said, again, within each city, especially Jerusalem at the moment. I think also in that comment, I would like to ask a question. Do you think that the current focus through media, let's say merely or heavily on Sheikh Jarah and other than Beta and Silwan and Lifta and so many other, by the way, they're building a settlement now in Beit Lahem at the moment, right? I think Professor Brendan is aware of that. We don't see that on media. Do you think that is just a way to attract more international support, perhaps because Sheikh Jarah already made it to that level? Or is it really at the core level of it a colonial ideology of, again, fragmentation, as you have said? What is it? Why do you think there's a heavy focus on Sheikh Jarah, while many and I just labeled, like, give an example of 5 Palestinian lands and areas are going through an annexation at the moment? What is that? Why is that going on?
Well, I think there's a couple of reasons. First of all, the level of activism and resistance on the ground amongst the residents of Sheikh Jarah is truly remarkable and astounding. Sheikh Jarah, the issue in Sheikh Jarah has been going on for years and years. This is not new. This has been happening for decades. And I think there are some amazingly brave and just really fantastic activists on the ground. I mean, Mona and Mohammed Al-Kurd, the Al-Kurd family, are on nearly every international media outlet, making sure that people know about Sheikh Jarah. So I think, first of all, let's say congratulations and big up that side of resistance. I think it's really impressive. Also, let's face, Sheikh Jarah is in Jerusalem. Jerusalem is hugely symbolic, hugely important for Palestinians and for the wider Muslim world as well. And so the spotlight on Jerusalem is obviously very significant for those reasons as well. And so I don't view it as a way of dividing and segregating by only necessarily focusing on Sheikh Jarah in this instance. I think I think it's just a lot to do with the fact that there is a lot of really heavy activism happening on the ground. I mean, when I was there in 2009, for example, Nawal, there was a significantly higher Israeli leftist presence in Sheikh Jarah. There were weekly protests on a Friday. And actually, what is quite interesting is that hasn't been as visible or as present as it once was, and I struggle to understand why that is. So yeah.
I see. And then, what are the tools and mechanisms, just briefly, what are the tools and mechanisms that, Israel as an occupier and colonial state or have been implementing, not just now, right? Ever since this annexation, Palestinian lands are going on, specifically in Sheikh Jarah and Silwan and Beta at the moment, right? To annex those lands. Because as we've, with your very concise historical background that you've given us, we kind of got the idea that Sheikh Jarah has been going through annexation since 1967. Thus, we say third of Sheikh Jarah has already been annexed, right? And now we're not even debating that, at least status quo. So, what are those tools and mechanisms that they're using?
Well, first of all, just to, again, just take it back a little bit and say, look, the modern history of Palestine is a confluence of colonialisms, right, with its own consequence in the lives of Palestinians today. So we have three main strands. We have historical colonization under the Ottomans and the British. Then we have Zionist settler colonialism that is ongoing. And then actually we have neo-colonialism of globalized liberal capitalism, where peace building is used as an interventionist tool designed to pacify and legitimate call and marginalize legitimate calls for anti-colonial resistance. And through the lens of colonialism, we see Israel's dual role as a settler colonial state from its inception and foundation to the present day, with the ongoing colonization of indigenous lands, and as a key actor in a globalized international system that is buffered and supported by a range of Western geopolitical interventions. And the fact that the relationship between Palestine and Israel is termed a conflict rather than an anti-colonial struggle is in itself an acquiescence to Israel's hegemonic stronghold. Rights to the land are framed as contested, and those resisting occupation are labeled as terrorists, with their very existence as Palestinians called into question. And the processes that embody this settler colonial logic, as Patrick Wolf, for example, or John Collins have previously noted, are elimination, expansion, exceptionalism, and denial. So indigenous land, in this case Palestinian land, that is confiscated is then in need of being settled by the settler, i.e. the Israeli population, a process that is achieved through a variety of means, including physical relocation, forcible transfer and displacement of the native population, destruction of the native population through physical violence or genocide, forced assimilation into the settler society, active discreditation of native claims to the land, and the use of colonial violence. And I think this is important as well, the use of colonial violence that renders life on the land for the indigenous populations untenable. And all across historic Palestine, we have ample evidence of this Israeli settler colonial logic in action, from attempts of elimination in Gaza, most dramatically evident, to the system of apartheid, a language that has now become modern parlance, even though Palestinians have been talking about it from the mid-80s, that controls the everyday reality for Palestinians living across the West Bank, Gaza Strip, and within Israel proper, maintained by the settler colonial architecture of control that utilizes violent spaces such as checkpoints to restrict movement and create these bantustans, uses surveillance to track and monitor Palestinians, all in an effort to make life on the land for the indigenous population untenable. And these are just some examples. So on a Sheikh Jarah level, as the site of anti-colonial resistance for the purpose of our talk, we see forcible transfer of the native population. We see that is situated along internment or administrative detention of the native population. We see physical violence enacted against the native population, both state-sponsored and settler enacted. We see this alongside attempts to discredit Palestinian entitlement to their land through the distortion of legal systems. And then the reference to the forcible transfer of Palestinians as being nothing other than a real estate dispute is again akin to the settler colonial logic of denial, attempting to discredit the colonial reality by downplaying its significance within a broader context.
Mm-hmm. Absolutely. And then, lastly, Professor Brendan Brown, I think, it's worthwhile to just, to briefly discuss with us the status quo of the verdict that has been issued recently from the Israeli Supreme Court on Sheikh Jarah and Silwan, or let's say, if not the verdict, the intervention of the Israeli Supreme Court. And what is the status quo of this case currently? What is going on before courts at the moment?
I'm quite remiss. I quite loath to actually talk about it because, a lot of my Palestinian colleagues just don't even pay any attention to the Israeli Supreme Court. It's just another tool in the occupation. Now, I mean, that's not great for a discussion on legal issues, and I'm fully aware of that. And the intervention by the Supreme Court, as I understand it, has been to kick the decision down the road further in the hope that people will lose energy, right? The immediate attention will be pulled away in the hope that we don't actually have to engage in a high level legal battle, and that they can just complete their annexation without the media attention and spotlight. So to be honest, I'm not going to try and go into much detail on the Supreme Court's decision. It's not something that I'm fully comfortable discussing or aware of, and I don't want to off that. But I just want to say really, really importantly at this time, because I know that's your last sort of question to me, is that we need to make sure as critical scholars that we don't segregate Sheikh Jarrah. We don't make Sheikh Jarrah as just the exception to the norm, because it is not. It is part of a struggle, a broader struggle that is not just the West Bank, it's not just Gaza, it's not just 48 Palestinians, it's the Palestinians that live in the diaspora, it's the Palestinians that live in refugee camps that have the right to return home as well. And all of these issues must be taken as a whole. So Sheikh Jarrah is an important cog, an important site of resistance in an important moment of time. But always let us remember that it is part of the wider context that is Palestinian resistance and struggle. And I really want to emphasize that point.
I absolutely couldn't agree more. I think, when we talk about the Supreme Court verdict or procedure that is going on, I think the first thing and maybe the only thing we should, mention here is that it is a tool, a mere colonial annexation of those lands. And I think we've seen that, long time ago. And, whether there is a court verdict or not, eventually, an occupier or colonial, they will annex lands. And I give an example about my own village. So, very briefly, I'm originally from, a Western village in Jerusalem, Hadassah or Ain Karim. And this village has been annexed in the 1948, right? And then after that, Hadassah has been under the UN protection, AKA that, Israeli military cannot destroy any houses or buildings, and they can also not build anything. So it is funny, just to emphasize on your point that I think when we talk about Sheikh Jarrah, when we talk about Silwan, when we talk about Beta, we need to put it in the context of the broader annexation of the Palestinian lands, which has been going on since the 40s, right? And so until, it's funny to see that until this very day when we go on holidays with the family and, my grandma would knock on, a house of her house. And then there's never a question between who lives currently in that house or her is, why are you here or why are you knocking on the door? It's simply, can I visit my house? And then the answer would be simply yes or no. So, that is just to, say that it is important to keep talking about the annexation of all of Palestine. Thank you, Professor Brendan. I think, you've given us a wonderful de facto background on what is going on. You talked about the tools and mechanisms of how they're going through. You even mentioned some events that has been going on last night in Sheikh Jarrah and Silwan, and you emphasized on the importance of not fragmenting the Sheikh Jarrah and Silwan from all of the annexation of Palestinian lands. So thank you for that. Now, moving forward to talking about the individuals, or let's say victims, individuals who are going through and living through those atrocities with Professor Samia. Professor Samia, what are we missing in this conversation in relation to the victims and individuals suffering the de facto implications of it, specifically as we're talking here in Sheikh Jarrah and Silwan and Beta at the moment? What are we missing here?
Yeah, before I start off to answer your question, I would like to thank you, Professor Nawal Hind, as well as the Human Rights Society, but you in particular for taking the initiative to have a conversation on this issue, on a very important global issue. And I must also begin, before I answer your first question, I must also say, begin with a caveat that unlike the other speakers, unlike Professor Brown and Professor Attar, I have never been to Palestine. I've never been to Israel, and I have also not taught particularly on this issue. Now, I have been reading reports and legal analysis, watching video clips of the attacks, their aftermaths, listening very closely to what people affected by the violence have to say. So in that sense, whatever I speak today is in a sense based on secondary sources and my own understanding of the law. But I have worked with victims and survivors of violence, of various forms of violence, and provided socio-legal assistance. After one such mass crime situation, which I shall not name right now, the victims told me it doesn't matter whether you make the perpetrators accountable under international law or under domestic laws, in international courts or in domestic courts, under this law or that law. What matters is that justice must be done by punishing them. Just get at them in whatever way you can. So that is a perspective of victims and survivors, which I often keep in mind as we discuss and deliberate a very important legal nuances on substantive, procedural, evidentiary law, jurisdictional matters. But at the center of all that is the victims and survivors, the people who are affected by all of this. So that's one thing I just wanted to highlight. And I agree with the previous speakers that when we talk about Israel and Palestine, not in terms of conflict or war, but rather in terms, it is a project of settler colonialism. We have an active oppressor and the oppressed, a colonizer and the colonized. And what we have been witnessing the last few years is this project of ethnic cleansing, persecution, apartheid by Israel on Palestinians. And the recent attacks are the latest in a long cycle of violence. Now, the question you asked me was, what are we missing something? I don't really think we are missing something, but I think I would like to bring more dimensions to the table. Professor Brown and Professor Attar have brought the colonial studies and the law of occupation perspective. I think I would like to bring onto the table the international criminal law perspective, as well as the international human rights law perspective, and also a feminist perspective into into the discussion that we are talking about. So I think in the midst of the international legal discourse, we cannot lose sight of the fact that we are in a huge humanitarian crisis. Thousands of people have lost their lives, homes, properties, livelihoods. They live in perpetual insecurity and fear without basic facilities of health, water, sanitation, their houses and lands forcibly taken away. And in the recent attacks, we see that there were a lot of children who were killed, and others who have been perhaps permanently scarred both physically and mentally. And there is, as I've heard these video clips and, civilians speak with utter helplessness at being disempowered in their own land. And I think it's important for the participants, for the audience, to keep the nature, the scale, and the duration of this humanitarian crisis, the duration which Professor Attar has been, has very emphatically pointed out to us. I think it's very important to keep that in mind. And then I would only like to bring in these other perspectives so that we approach the issue from multidimensional perspectives.
Thank you so much, Professor Samia, for emphasizing on that. Now, on the basis of your own expertise that you have just mentioned, working with victims, going through violence and conflicts, colonialism, what are the available protection, methods and tools under IHL? And what are the most efficient protections to be sought or implemented in this situation, right? So let's keep in mind the current and let's say maybe the unique circumstances of Palestine as a state going through, or as a nation to, going through under occupation and colonization. What are the tools that the IHL provides for those victims, and what tools can be successfully or efficiently implemented and not just theory?
Well, I can highlight two of the tools. One is within international criminal law, and the other is on international human rights law. But to your related question as to how efficient these protections can be, that's something that requires further discussion, because earlier I was listening to Professor Attar say that law of occupation is ill-suited to deal with the Palestine situation, and I'm really not sure whether international criminal law is going to give us an absolute solution, or international human rights law is going to give us a fantastic solution. I think it's multi-pronged, and maybe a bit of many things might work. So let me start with the international criminal law. And here I'm specifically, I want to highlight the Rome Statute of the International Criminal Court, which is intended to prosecute and punish individual perpetrators committing some of the most grave crimes under international law. And these are genocide, crimes against humanity, war crimes, and the crime of aggression. And the aim of the ICC is to promote accountability for the commission of ICC crimes, regardless of who the perpetrator may be, in an effort to deter such crimes in future. Now, Palestine had made a referral of the grave violations committed against its people to the Office of the Prosecutor, that is the OTP, and this was not the first case of referral of a situation to the ICC. I'm sorry, I'm hearing some disturbances. Yeah, okay, thank you. So there have been other situations of referral, like Uganda or Central African Republic and so on. But what is interesting with regard to Palestine and the International Criminal Court is really the timeline. So I want to very briefly highlight this timeline. So 2nd January 2015, Palestine acceded to the ICC treaty. And this would enable then the ICC to investigate and prosecute ICC crimes committed within the territory of Palestine by nationals of any state, including Israel, and by Palestinian nationals committed anywhere. While Israel is not a party to the ICC, Palestine's accession paves the way for an ICC investigation and prosecution, possible prosecution, we don't know that yet, of potentially anyone, including Israeli citizens on Palestine territory. Now, 2nd January 2015, along with the accession, what Palestine also did was, very interestingly, it gave a declaration under Article 12.3 of the statute, conferring on the ICC jurisdiction for any crimes committed in Palestine since 13 June 2014. Now, these dates are important. This was a 13 June 2014 is a date which was chosen by Palestine. And I will tell you why that is significant. The dual action of accession and declaration is interesting because with accession, the ICC would have the exercise jurisdiction only after the ICC statute entered into force for Palestine, which would have been 3 months later. That is 1st April 2015. And no retroactive jurisdiction would have been possible. But because Palestine gave this declaration and it agreed to the jurisdiction of ICC for crimes committed from 13 June 2014, so retroactive jurisdiction became possible. And this meant that the violence in Gaza and West Bank in July and August of 2014, this was a major violence that would then get covered. Now, after this accession and declaration on 2nd January 2015, on 16 January 2015, ICC's erstwhile prosecutor, Fatou Bensouda, she announced the opening of a preliminary examination. Now, a preliminary examination is basically to collect all evidence and to see whether there is enough ground for a formal investigation. So the preliminary examination began in January 2015, and it went almost for 5 years. It finished somewhere in December 2019. And in December 2019, the ICC prosecutor issued a statement that the office found that there was reasonable basis to believe that in the context of Israel's occupation of the West Bank, including East Jerusalem, members of the Israeli authorities have committed war crimes under so-and-so. So it found that there was this reasonable basis to go for an investigation, but the ICC's prosecutor, just to play safe, because there were complexities involved with regard to the territoriality issue. So what the ICC prosecutor did was to make a request to the pre-trial chamber of the ICC on the territorial scope of ICC's jurisdiction to have clarity at the outset before a proper investigation commenced, because otherwise it would be a waste of time, money, energy, human resources. Victims and survivors would have their hopes high for the next 5 years. So to avoid all of that, the prosecutor sought this, this request from the pre-trial chamber. Now, 5th February 2021, the chamber decided by a majority that the court may exercise its criminal jurisdiction in the situation in Palestine, and that the territorial scope of this jurisdiction extends to Gaza and the West Bank, including East Jerusalem. So it also unanimously, because one issue which keeps coming up was about Palestine statehood, whether it is considered a state party and so on. So the trial chamber also, pre-trial chamber also decided unanimously, it ruled that Palestine is a state party as far as the Rome Statute is concerned. So the implications of the trial chamber's ruling are that it has made no findings on the alleged crimes which have been identified by the office of the prosecutor, but it held the OTP to have competence to make the investigation into the alleged crimes. So March 2021 onwards, there is a formal investigation that has opened up into war crimes in Palestine. And in May 2021, in the middle of all the violence which was happening, the attacks which were happening, the prosecutor actually warned that individuals involved in the new eruption of violence may be subjected to an investigation. And she said that the prosecutor also said that she would press charges even without the cooperation of Israel, which accused the OTP of anti-Semitic bias, and it rejected the membership in the ICC like its close ally, the US. So at present, the situation is that there is a formal investigation which has been started by the OTP. The prosecutors has been mentioning war crimes in 3 or 4 of her statements. I've been studying her statements closely. She has not really mentioned crimes against humanity. She is beginning, I think, with war crimes, but there is no saying how this will, during the investigation, if there is evidence, then there are other crimes which are likely to be added. Now, in this, there are a few things that we must remember. Firstly, opening an investigation into the situation in which ICC crimes may be committed. This means that all the acts and omissions of all sides to the violence would be equally investigated. Okay, so it is possible that not only Israeli nationals, but also Palestinians, especially Hamas officials, may also be investigated. So that's the first thing that we have to take note. Secondly, the ICC operates as a court of last resort on the basis of principle of complementarity. So if domestic courts, particularly Israeli courts, are able to convince the ICC that, they retain the primary jurisdiction, and if they are able to convince the ICC that, they will be able to prosecute the perpetrators, and it won't just be a sham, then it is possible that the cases may not go on in the ICC. Thirdly, ICC is not a panacea. We cannot pin all our hopes on the ICC. It can only prosecute a few persons, mostly political leaders and officials who led the attacks. This is from the other situations which are before the court. We are seeing it is only the top leaders that are being prosecuted, and particularly its track record on gender and sexual violence has been very, very poor. I don't want to elaborate on it right now, but if there are questions and questions, I can elaborate on that later. And lastly, we have a new Prime Minister of Israel, and we have a new prosecutor of the ICC. So it will be interesting to see the developments in the next few months. And the crimes that are potentially attract the jurisdiction of the ICC statute include war crimes. So it could be grave breaches of Geneva Conventions, willful killings, torture, extensive destruction or appropriation of property, not justified by military necessity, unlawful deportation, unlawful confinement, other serious violations, and crimes against humanity, which include murder, persecution, apartheid, forcible transfer of population, imprisonment or severe deprivation of liberty, sexual, gender-based violence, other inhumane acts. So we have talked about ethnic cleansing, but I just want to highlight here that ethnic cleansing itself is not an ICC crime, but where it is usually done through deportation and displacement and mass killings and persecution, and all of those are either war crimes or crimes against humanity under the ICC statute. And we don't know what crimes the prosecutor will indict and who will be indicted, if at all. So that is the situation as far as the international criminal law is concerned.
Thank you.
Yeah.
Yes, thank you so much, Professor Samia, for this in-depth elaboration on the ICC as a tool and what is really going on ground. I think this is a great example to take from there. How do you think that ICC, right, as a tool that has been is currently using, because that was an answer to a question where I asked what are the tools to be implemented to protect the victims that going through occupation and colonialism, and as you have said and mentioned at the end, that this court jurisdiction also extended to the occupied, to the resistance. In other words, this jurisdiction or this court might, we're still waiting, but it already applied its jurisdiction on the other party, because this is how it processed. But we're not sure if it's going to prosecute the Palestinians, but we're still gonna see. But theoretically speaking, how do you think, or what do you think of applying this tool in an equal stance with the occupied? Can we put the occupier and the occupied, the colonizer and the colonized, on an equal stance before a court? And this is really what is going on. So again, in other words, can we say the ICC is a tool that we can use to protect the victims that going through occupation and colonization? I think this is also an interesting question, and that really goes back to when Professor Mohsen Attar has mentioned that all the public international law, with all of its sectors, the terminology of it was substantially drafted from a colonial perspective, and it was not and then I will add up to it and say it was not drafted to provide any protection or any termination to colonization or occupation, or to even maybe say provide a shielding to those victims. So how can we go around that dilemma, right? Because we want to apply this ICC jurisdiction, right, to put an occupier on a stage and say, hey, you did 1, 2, 3, it's a violation, it's a war crime, and let's protect the occupied. But now the ICC is saying, which is what it is under their own statute, that we also need to put the occupied on an equal stance and, talk with the Palestinian resistance, let's say, example, Hamas, on an equal stance. Can we do that? Is it efficient? So, and this is why it goes back to the original question. Is it an efficient tool and mechanism to protect the occupied and the colonized? Is it an efficient tool?
Yeah, I think its efficiency is questionable, but I think the ICC crimes have a very, very high threshold, and the way the Rome Statute was drafted, the whole idea was irrespective of who commits the crimes, if those crimes are committed, then those persons and the leaders, I mean, it doesn't spell out, but in practice we see that they are going to be made accountable. So it doesn't really take into consideration the power dynamics and the colonial and colonizer and the colonized, or the, it doesn't, or the oppressor and the oppressed. But what it looks at is if those crimes are committed, irrespective of who is committing the crimes, but it has a very high threshold. And if that threshold is met, then that person, that individual is going to be prosecuted. The ICC also has certain provisions related to victims. There is a victims trust fund. So there is, there is a compensation that can be reparations, which can be ordered. So there are all those, there is a witness protection, victims and witness protection unit. So all of that also exists. But that is where I think, Naval, it is important to examine the international human rights law as a tool in conjunction with the ICC, because in international human rights law, we see that there is a recognition of that, of the power dynamics between the oppressed and the oppressor, the colonizer and the colonized, in a sense, which which the ICC does not recognize, because it is only focusing on crimes committed by individuals, irrespective of who those individuals may be. So the recent Human Rights Watch report, which came out in April 2021, it's called A Threshold Crossed, Israeli authorities and the crimes of apartheid and persecution. It's a 200+ paged document, and that is a document where where the Human Rights Watch in that report very clearly, and it elaborates on how the elements and the ingredients of the crimes of apartheid and persecution are met. And these are crimes against humanity, and the elements of those are met. So very categorically, its findings are that Israeli officials have committed the crime of against humanity of persecution and of the crime of apartheid. So that is the Human Rights Watch report is definitely a very, very important tool for any kind of advocacy for justice. But the other aspect is also, if we look at the Universal Periodic Reports, for example, the third cycle of the Universal Periodic Report of Israel, which happened in 2018, there were many, many countries, Venezuela, Russia, Malaysia, Qatar, UAE, Maldives, many countries, which called upon Israel to recognize and respect the inalienable right of self-determination of Palestine, to stop settlement construction of Jewish population, to stop transfer of Jewish population, to stop demolition of private property, to stop the heinous practice of collective punishments, to increase access to Palestinians to clean water, electricity, health, education, and so on. So that is a very important. And the CEDAW committee report as well, the 6th periodic report on Israel 2017, that says very clearly that of how Israeli security forces, the practice of night raids, the other kind of practices and policies, how it disproportionately affects women and girls. So that is something that that also we can take into account. So I think a combination of the ICC and the of international criminal law and international human rights law may provide us with a better tool than to look at them as something separate.
Absolutely, absolutely. Thank you so much, Professor Samia. Now, I think, to wrap it all up, before we go ahead and take the audience questions, I think we've already received several of that. What do you think, finally, what are the next steps, right? What can we do moving forward from this, status quo of where, the victims are going through those atrocities? What is next, in your opinion?
I think, something that I didn't have time, but I want to take 1 minute to talk about it is also, it's important to bring in a feminist perspective on violence, aggression, occupation, and that can't be ignored. And there's a lot of feminist scholarship that has found wars, conflicts, aggression, violence to be gendered, and political military practice where masculinity as an ideology justifies male domination is being promoted. So Susan Brown Miller, Cynthia Enlow, Professors Hilary Charlesworth, Christine Schinken, who have actually critiqued public international law and said how these don't really bring out women's voices, women's experiences to the forefront at all, and they don't even take that into account. And this is something we see in many of the discourses around the Palestine issue as well. We keep talking about Palestinians, but who are these Palestinians? Are they a homogeneous community? And how do we understand the experiences of Palestinian women to be different from others? How do we understand the experiences of Palestinian children to be different? I think that is something that is required to be done. And what has helped has been amazing feminist solidarity across the board. Jerusalemite Women's Coalition, consisting of women's groups from across different parts of Israel and Palestine. There are South Asians for Human Rights. There are various statements. I think those are also important. In terms of the next steps, I think one of the important things I would like to highlight is that peace and justice must be seen as mutually reinforcing imperatives. We cannot go for one or the other, but look at them as reinforcing, and justice processes must address violations of rights of Palestinian women and children. Secondly, whenever peace negotiations and talks happen, Palestinian women have to be brought onto the negotiating table. And we have, for example, the Security Council Resolution 1325, which treats women not as victims, but as active agents of change, as peacemakers, peace builders, negotiators. So I think that is important. And thirdly, I think ICC's investigation into the violations in Palestine must focus on gathering evidence on particular forms of atrocities perpetrated against Palestinian women and children. There was a poem which I wanted to share with everyone. It will take only 1 minute because I want to read only the excerpts. Can I do that?
Of course, Professor Samia, go ahead.
Okay, so I'll just end with that. This is one of my favorite poets, Rafeef Ziadah. She's a Palestinian woman, and she had written this poem called Shades of Anger. And there was a protest at her university, and an Israeli soldier kicked her and said, "You deserve to be raped before you have your terrorist children." She didn't say anything at that time, and later on she penned this. I'm not going to read the whole thing because of a lack of time, but I want to read excerpts from it because it's very, very powerful. The first time I heard it was 11 years ago, and it moved me, and I looked for this poem to share with everyone today. So it starts like this: "Allow me to speak my Arab tongue, before they occupy my language as well. Allow me to speak my mother tongue before they colonize her memory as well. I'm an Arab woman of color, and we come in all shades of anger. And did you hear my sister screaming yesterday as she gave birth at a checkpoint with Israeli soldiers looking between her legs for their next demographic threat? Called her baby girl Janine. And did you hear Amna Muna screaming behind her prison bars as they tear gassed her cell? We are returning to Palestine. I'm an Arab woman of color, and we come in all shades of anger. So who's that brown woman screaming in a demonstration? Sorry, should I not scream? I forgot to be your every Orientalist dream. Genie in a bottle, belly dancer, harem girl, soft-spoken Arab woman. Yes, master, no master. Thank you for the peanut butter sandwiches raining down on us from your F-16s, master. Yes, my liberators are here to kill my children and call them collateral damage. I'm an Arab woman of color, and we come in all shades of anger. So let me just tell you, this womb inside of me will only bring you your next rebel. She'll have a rock in one hand and a Palestinian flag in the other. I'm an Arab woman of color. Beware, beware of my anger.
Thank you. Thank you so much, Professor Samia. That was very, very beautiful and nicely concluded, I would say. Couldn't be, concluded better. Thank you so much, Professor Samia, for everything. And now, without any further ado, let's start with the questions that the audience have sent us. So we're going to start from a question that is directed to Professor Mohsen Attar. So it says, and I'm going to read it as it is: beyond framing occupation to be an intersection of multiple concerns, be a violation of self-determination or an apartheid and even a settler colonial project, do you see any potential with arguments on how using the current vocabulary of law is increasingly titling towards illegally prolonged occupations, works of El Gross, of instance? So that is the first question, Professor Attar. I hope that was clear.
It is clear, yes. So there are really two approaches that when we look then at instances of occupation and the legal scholarship surrounding it, there are two approaches that occupiers tend to take, or correction, resistance to occupation tends to take. One is pointing out the violations then in terms of the management. So failing to uphold then the duties that the occupier has, violations then of the rights of the occupied. And there are a variety of instances where that's been carried out. I think for the most part, this can be successful, but only in those temporary ones. In the prolonged ones, in the long-term ones, what we've seen is an increase in the arguments around the legality, questioning the legality then of the occupation itself, and whether they tend to shoehorn in points about settlement or about self-determination or violations of sovereignty. But regardless, what we are seeing then is an increasing then shift towards issues around the legality. And that is what we saw this past couple of weeks with the Irish, a question that I'd note Dr. Brown ducked.
Okay, thank you so much, Professor Mohsen. I think this question is directed to Professor Brendan now. So I'm going to read it as it is. The newly formed Israeli government, this is an interesting one for us to kind of comment on, consists of a coalition which includes political parties with varied ideologies. Okay, in light of this, can we expect a change in the action of Israel over a period of time? I think it's an interesting one for you, Professor Brendan, to, if not answer, comment on.
I will do exactly that. But first of all, I wouldn't want to be accused of ducking anything, not least from my colleague and mentor. So I think it's a really important. Can I, if you allow me 2 seconds to answer what Mohsen put forward? I think the point he raised is really significant and important. And if I can put a little bit of context on that, because whereas I think he's far better equipped than I am to talk about the sort of the legal implications of shifting from occupation to annexation and what that really means in terms of possibilities. But I think there's many reasons why the Irish government may have done this. So the first, and I just want to put this on the table. The first thing is this most recent phase of violence in Gaza saw an unprecedented Irish response on the ground. The activism that was taking place on the ground in Ireland was genuinely significant, and it was led by grassroots organizations, the general public, but also by a number of independent senators in the Irish government who are trying to implement the Occupied Territories Bill through the Irish Parliament at the moment, which will make any goods that come from occupied territories need to be labeled as such. And that's quite significant. So the government is feeling the pressure from the activist community on the ground, and that's something I'm really proud of. But also, I think there's another reason, and the other reason, of course, is that Ireland in the forthcoming year is about to take over the chair at the UN Security Council. So maybe this is an opportunity for Ireland to pivot itself with its own history of dealing with the legacy of colonialism and dealing with perhaps ongoing colonialism, if we want to call it that, even though it's a loaded terminology in our own context. So I think that's why Ireland has perhaps taken a lead on that. Okay, and I think it is quite significant. And then I guess I want to maybe just say one quick thing about the ICC and the issue of how Palestinians might view the ICC. I mean, I'm perhaps not as fully critical on the potential of international law to have any useful purpose when it comes to the case of Palestine, but I'm also realistic, as are the majority of those who are engaged in resistance activities on the ground in Palestine. They don't view the ICC as the panacea. In fact, it is just one little tiny tool in the wider arsenal of resistance tools that exist, if you excuse the pun. And in many ways, I think the thing that Israel is absolutely terrified of is boycott, divestment, and sanctions, because that's where it hits hardest. That's where it hurts the most. And I don't think we can end a conversation today without talking about the importance of sanctions and the importance of really fundamentally shifting our language around how we engage with that. And then there is another issue around that as well. There is a piece of work done by Artie Imses, most recently published from Queens in Canada, who's talked about the potential of the International Court of Justice advisory opinion actually being the better way to go, and actually having another second advisory opinion on the situation in Palestine rather than going through the ICC, which will, as Professor Uma already pointed out in great detail, will only prosecute maybe one or two people, if any, which it won't, which we're realistic about. And then in fact, it'll be a way of throwing everybody under the bus, and it'll be a way of one side, or each side is in resistance versus colonial aggression, which we cannot allow to happen. In short, to the answer about the Israeli government, no. We don't expect any change. What's happened is they've brought in a even more right-wing fundamentalist lunatic to take over the head of the government, who believes that they have some biblical right to be there, and who is deeply propped up by the settler community, many of whom are involved in the ongoing ethnic cleansing of Palestinians in Sheikh Jarah. So no, I don't think anybody holds out much hope for the change of the Israeli government.
I absolutely agree. Absolutely agree. And then we have another question here, and I believe it is also for Professor Mohsen. It says, even if in the framing of unoccupation, which is something that is increasingly accepted, there are a few things that may need a more conversation. What is your comment on that? That's a commentary on this statement.
Can you say that statement again? I don't believe that I actually caught it.
Okay. So once again, it says that, you know, give me 1 second. So even in the framing of an occupation, which is something that is increasingly accepted, there are a few things that may need more conversation. It's a very broad statement. And then he goes on and says, one, how technical arguments give legitimacy, such as occupation denial through a Blum thesis, or what the HCJ does, or Gaza not being occupied. Two, is also discussing what Palestine is occupied, between quotation. Countries like India have always taken the Covenant UNSC 242 stance of post 67 occupation. So what's your comment on that?
Okay, I think I see where they're going with this.
Yeah.
So the first one, and this, I take the point then that Dr. Brown made earlier. We have to be very cautious with the language that we use. So I don't think that occupation is becoming increasingly accepted. I think there has been an attempt to normalize the occupation, but an attempt to normalize the occupation by very much the Israelis and the Americans, and to a lesser extent then the British as well. So there is that. But if one looks across the African continent, across the South American continent, across the Asian continent, which would then make up roughly, then we would say somewhere around 80 to 85% of the world's population, there's an outright rejection then of the occupation and a demand for some type of justice then for the Palestinians. Because of the Eurocentrism of the media, because of the Eurocentrism of the Security Council, and because of the Eurocentrism of international law in general, we tend to just hear those voices then of what we would often refer to as pale, male, and stale. Sorry, Brendan. Now, that being the case, we have to say, what is the popular position around occupation? Well, the popular position around it is it's illegal, and there should be a return then to the 67 borders. As simple as that, as in we see that then across the non-aligned movement, you see it across the Group of 77, you see it then even in terms of the recognition of statehood we're talking dozens of countries around the world. So it was very interesting to me a couple of years ago where there was this debate around what would happen if Palestine declared itself a state. Well, it had already done so some years ago and has already been recognized by a large number of countries. So I get it's not recognized then by European powers, but again, this is where we point to the Eurocentrism of international law and even the Eurocentrism of our own thinking. So we're still looking for some type of legitimation then by Europeans before we actually embrace the fact that we are then a state. So to go then to the question, then to say, yes, the challenge with anything, as soon as we start delving into the law, and again, I take the point then that was made by my two colleagues on this panel. As soon as we get very technical about it, then what we can do is ultimately obfuscate a lot of the underlying issues. And the underlying issues are really quite blatant and quite evident to us. So what you have then is, as we were saying, ongoing colonization. That is it. There's nothing more to it than that. And I wish you had kind of asked me the question that you asked them in terms of what would be the next steps. And largely because I would have gone back to what I said at the outset, which is we require greater honesty in relation then to the debate. So when I say greater honesty, recognizing that in fact, the new prime minister, as was pointed out then by Brendan, has spoken glowingly about ethnic cleansing. It has said specifically population transfers. And I remember smiling at the time when someone suggests a new beginning. And I thought, but it's not even about, out of the frying pan and into the fire, right? Is that we're looking then at the different levels of hell and saying, which level are we now occupying then? So it's more along those lines. Now, I'm being quite forceful, but the point is clear. You do have a segment within Israeli society, a very large segment, that would be happy with the ethnic cleansing of the Palestinians. And that is very much what we find ourselves in. It's a state where, or a series of circumstances where what we have is a state that is saying, I want to ethnically cleanse you, I want to annex your land, or I want to permanently incarcerate you and use you as a cheap, practically enslaved labor class. And you have much of the international community kind of standing by as this is manifesting. So what is evident from every Israeli policy that we've seen and every politician that has come forward, at least in the past generation, is that there is no intention of ending the occupation. What there is the intention of doing is securing an iron grip over the lands and ultimately controlling the lives of Palestinians, which is why, again, in terms of the framing of it, framing it as a settler colonial, then a form of settler colonial conquest, framing it as a system of apartheid, as has come out recently, is what is most effective. And again, as Brendan pointed out, it is precisely for that reason that Israel is resisting both the term apartheid and resisting then BDS as strongly as it is. Because once we go down that route, then we turn to the South African model, and no one is willing to accept a state such as the South African model. So even then we see the language and this pushback, and you can see this within British politics very heavily in terms of the definition of anti-Semitism, and linking it then to using this term apartheid and saying using that term apartheid in relation to Israel is a form of anti-Semitism. So that in itself is pointing to, this is where there were attempts then by the Palestinians then to frame this precisely as it is, an anti-colonial struggle then against a settler colonial state that is seeking to implement apartheid policies across then the region against the indigenous population. Simple as that. So once we bring that back and we understand that, then all of that, those legal technicalities turn into the kind of mumbo jumbo that they are. But I'm a legal scholar, right? And so of course I'm going to speak then to the technicalities, the legal technicalities as they are.
Absolutely. Thank you so much, Attar, on this. So this question is not directed to anyone. I'm going to read it out loud, and feel
Can
free
I interrupt,
to...
sorry, quickly, and say that apologies, but I must exit now. I had a meeting that began 20 minutes ago that I'm in fact chairing, and everybody's knocking on the door. So I do have to get going. But like everyone else, my appreciation then to you and to the Law Society and to the university for hosting me. It was a delight to be here.
Thank you so much, Attar, for participating with us, and looking forward to see you again. Thank you. Have a good day or night. Okay, so proceeding with the question that we have here, it says, considering the fact that United Nations has not taken a strong stance against stopping the atrocities being committed by Israel forces, what resource is available to the citizens of Palestine? And I think that kind of Samia kind of underlined part of this question, as well as Professor Brendan. So feel free to answer this question.
I don't really have, I think I have already kind of answered this question during my talk. So maybe I would leave it to Professor Brendan to speak.
Okay. Professor Brendan, do you wish me to reread the question again?
Please,
okay.
Please,
so,
if you don't mind.
Yes, it says, considering the fact that the United Nations has not taken a strong stance against stopping the atrocities committed by Israeli forces, especially I think they're talking about the current atrocities in Sheikh Jarah and Silwan and Lifta, what resources are available to the citizens of Palestine? I think it'd be an interesting one to answer through a colonial lens and perspective more than a public international law one.
Well, I mean, I guess it's about really promoting the BDS message again, and looking for international condemnation and international solidarity and international support that I do think is increasing. And I don't know what it's like in everybody's various spaces or what it's like in India at the moment, but I do see a bit of a shift in terms of support for the Palestinian situation, for the Palestinian cause. And as I said earlier, certainly the most recent spike in violence in Gaza, we really did see that public outcry in Ireland. And that was something that was really inspirational. I mean, do we really expect the United Nations to weigh in occupied East Jerusalem with blue helmets on the ground and, you know, stop this from happening? I mean, the reality is I don't think we expect that. I mean, also, I mean, we should also be very clear. I don't necessarily think that the United Nations has a wonderful record on the ground in Palestine anyway. I mean, a lot of people might say that the United Nations helped facilitate the ongoing refugee situation from 1948 onwards by having treated it as a humanitarian issue as opposed to a justice issue, when refugees should have been afforded the right to return and shouldn't just have been afforded humanitarian assistance. So it's an interesting one for me. I think in many ways when we need to ask Palestinians how they feel that that they need to proceed next. I think there's a lot of joined up thinking on the ground, a lot of NGOs, a lot of Palestinian NGOs and activist groups working together. As I said, a lot of international solidarity work happening, and a lot of amazing young Palestinian scholars and critical scholars working in organizations like Al-Shabaka, based out of Ramallah, who are publishing work that is way ahead of a lot of the modern day thinking around Palestine, and actually returning to critiques that were put forward in the 70s and the 80s in the language of decolonization. And actually, Al-Shabaka published in 2012 a big report on the language of apartheid. So, you know, it's all happening there.
Yes.
It just happens against it just happens against the backdrop of, you know, a real rogue state that has got away with such heinous settler colonial violence.
I see. Thank you so much, Professor Brendan. I think we have tons of other questions, but for the purpose of the timing of this event, I think it will be enough to take another 2 questions. So again, this question is not directed to anyone. Feel free to answer it. The Israeli forces have severely restricted freedom of Palestinian journalists in the region, and I think we can answer that in the context of what is, you know, going on at the moment, again, in Sheikh Jarah, Silwan and Lifta. Is there any resources in international law to protect media beyond their rights as civilians? You know, I think this is a question we can take. Professor Samia or Professor Brendan?
Do you want to tell us the other question as well, so we can get a little bit of a couple of minutes to just think about it? Do you want to give us the other question?
Yes, absolutely, Professor Samia. So the last question that we have received from the audience says, what are, you know, the current situation of, or let's say, what is the legal framework of Palestinian women being raped at checkpoints, specifically in Palestine? And I think this comment has been says that there is several documented cases on this regard. So yeah, I think what I think her name Brigitte want to say is, what are the available tools and to protect those victims of a rape within the context of occupation, and also what is the framework under public international law for this situation?
Okay. I think the CEDAW committee, for example, has pointed this out quite a bit. It has raised concerns, but again, the work of the various treaty bodies is in a sense soft law, because it can make its recommendations, it can make very scathing observations, but if the country concerned is not too bothered about its reputation in international community, or it is it has its strong allies, it may not really follow up on those recommendations which are made. So there have been repeated recommendations, there have been reports, and these reports, in a sense, they make these atrocities more, they give it visibility, they give it global visibility. And as far as the ICC statute is concerned, gender and sexual violence, there are various provisions relating to that which can be attracted. But ICC as a tool, we have already talked about some of the drawbacks related to that. So it is, I mean, it's really difficult at this point to say this is a tool which will be effective to protect the women. I think, a lot of international outrage, international protest, maybe sanctions, these are the kind of things that could help. Yeah, that's about what I would say at this point.
Thank you so much, Professor Samia. So I would apologize to the audience because we still have, I think, another around 5 questions and wrap it up to here. But, to just wrap up our event today, is there anything, Professor Brandon or Samia, you would like to add or just to state at the end of our event?
Just in regards to the targeting of journalists, that is covered under customary international law, but also one of the additional protocols to the Geneva Conventions mentions the targeting of journalists as well. So yeah, it's prohibited, but it doesn't matter. Clearly, that's the point. None of this matters. That's not true. I obviously don't believe that. But what I think it's very important that we keep having these events and we keep spreading the locality where these events take place and globalizing them and internationalizing them, both with our panelists as well. And I'm always very remiss to come on to panels like this sometimes, because I think we need to make sure that we uplift Palestinian voices and make sure that Palestinian lawyers are talking about these issues as well. But and having spoken to a couple of Palestinian law friends, they have also said that there is great benefit in having international voices sharing the platform and having these conversations. So my final thing would just to be to say thank you, and for us to look beyond international law as being this kind of panacea, this saving grace that's going to liberate Palestine. It's going to take a lot more than that. It's going to take a confluence of resistance and international solidarity beyond legal frameworks and structures that, as Mohsen and Professor Uma have pointed out, are often skewed towards the colonial power and the Eurocentric in their outlook. So, Garamila Mulgat, thank you very much for having me.
Thank you so much, Professor Brandon. It was a delight. Thank you, Professor Brandon. Thank you, Professor Samia, and of course, Dean Mohsen Attar.
I didn't say those last few thoughts that you asked.
Of course, Professor Samia. Go ahead. Of course.
Okay. I just wanted to respond to something that Professor Brendan had said. You know, he wasn't sure about how much of support there is in India for the Palestine issue. I think there's a lot of interest, and of course, historically, India has always been very supportive of the Palestine issue. And I think a large number of people, even today, are very, very supportive of the issue. And on your question on journalists, I thought, in addition to the response that Professor Brandon gave, I think there's a lot of jurisprudence which is also developing around human rights defenders. So that also could be used. And my final thoughts, I kind of echo what Professor Brendan said, and I think international law as a response or as a tool can only be part of the solution, but not the entire solution. I think we have to look at it more holistically, look at, you know, possible diplomatic processes, peace processes, other social, political, economic processes, in addition to global solidarity, and in addition to hopefully some kind of international sanctions, either from the UN or from individual countries or from regional groupings. I think those, you know, it is everything put together so international law in that sense is possibly part of the solution. And thank you.
Couldn't agree more. Of course, couldn't agree more. Thank you so much, Professor Samia, for being with us today and sharing your insightful scholarship and thoughts with us. Same thing, of course, go for Professor Brendan and Mohsen. I think I would like to wrap it up also myself and say that, you know, again, as a Palestinian, maybe lawyer and a young scholar, I think what Professor Brendan and Samia, you know, underlined is very important indeed to, you know, apply or add this international element of, you know, scholarship or activism into, you know, the Palestinian case, and especially what is going on now is indeed very important in this frame. So thank you everyone for being with us today, and apologies for the ones that we couldn't respond to their questions. Hopefully we can do maybe in another lecture. So thank you everyone, and I wish you a good day or a good night, depending where you are. Bye-bye.